Good morning. I'm Adjudicator Frank Caprio, Chief Borough Cloister Adjudicator of the Providence Borough Cloister Actuality in Rhode Island. And what I'm about to allotment with you is article that in my 30 years on this bench, I never anticipation I would witness. Let me set the arena for you. It's December 10th, 2025, a Tuesday morning, and my attorneys is already packed afore 9 o'clock. Chat campaign fast in Providence. Abnormally aback you've got Secret Service agents lining the perimeter of my courthouse and account vans parked on every bend of Washington Street. The case afore me today involves Baron Trump, the 18-year-old son of Admiral Donald Trump, currently serving his additional appellation in the White House. Now, I appetite to be bright about something appropriate from the start. I've been an adjudicator for best than best people have been alive. I've credible, powerful people airing through these doors. I've seen bodies with money, with connections, with attorneys who charge more per hour than best association acquire in a month. But what happened today? What I witnessed in my own courtroom. Challenged aggregate I accept about the American amends arrangement, and tested the actual foundation of what it means when we say in this country that no one is aloft the law. Baron Trump was charged with several austere offenses, stemming from an adventure that occurred on November 28th at a downtown Providence bistro, alleged Club Karma. The accused accommodate advance and battery, underage drinking, control of a fraudulent identification document, and witness intimidation. Now, before we even get to the facts of the case, before we alike altercate what actually happened that night, we allegation to talk about article that acutely afflicted me. As Baron entered my courtroom, he was accompanied by 8 Secret Service agents. 8. Do you accept what that means? It agency the Admiral of the United States believed his son needed that akin of aegis in a municipal cloister in Providence, Rhode Island. His accustomed aggregation was led by Theodore Lawson, a aloft Solicitor General who has argued dozens of cases before the Supreme Court. This man has argued for the accomplished cloister in the land. He's the affectionate of advocate most people could never afford. And there he was, continuing abutting to an 18-year-old kid who allegedly assaulted addition at a nightclub. The alterity in resources, in power, in aggregate absolutely was immediately credible to anybody in that courtroom. Let me acquaint you what actually happened. On November 28th, David Martinez, a 22-year-old contempo graduate from Brown University, was adulatory a colleague's retirement at Club Karma. The club is exclusive, alone for those over 21. Aegis is declared to be tight. But a back Baron accustomed that night presenting a counterfeit ID to the bouncer, article arresting happened. The bouncer looked at that fake identification, glanced up at Baron's face, and artlessly coiled him through. No questions asked. The Aegis footage shows the bouncer accustomed him immediately. He knew absolutely who this was. And in that moment, the rules changed. The bouncer accustomed someone underage into a 21 additional establishment because of who his ancestor is. That's the first domino that fell. Once inside, Baron began bubbler about immediately. Multiple assemblage placed him at the bar with a cocktail in his duke within minutes of arrival. The nightclub's internal cameras captured him loud, animated, already assuming signs of intoxication by the time David Martinez even knew he was there. Now, here's where it gets serious. David, carrying 2 drinks and walking through the crowded bar, accidentally brushed shoulders with Baron. It was barely contact. The affectionate of affair that happens hundreds of times every night in every nightclub in America. Except this wasn't with aloof anyone. This was with the president's son. According to the police report and the beholder affidavit we heard, Baron's acknowledgement was immediate and violent. He effective David by the collar with both hands. He airtight him into the bank with abundant force to send drinks, aerial, and bottles shattering across the floor. David approved to apologize. The Aegis footage captured his aperture moving, acutely attempting to de-escalate, but Baron wasn't interested in accepting or apologies. Aback David tried to airing away, Baron followed him. He agaped David's glasses off his face. He shoved him to the ground. And then, in a moment that would ascertain this entire case, Baron shouted words that made all-embracing headlines. He said, and I adduce anon from the police report, "Do you perceive who I am? I'm Baron Trump. My ancestor was the president. He still runs this country. One buzz call and you're done. Nobody messes with a Trump." That's a testant intimidation. That's appliance presidential adeptness to threaten someone. That's the affectionate of conduct that in my courtroom, in any courtroom in this country, after effects in serious consequences. Aback, David tried to acquaintance police. The intimidation continued. He accustomed bearding phone calls cogent him that filing charges against the son of a sitting president would account doubtful complications. Someone warned him that this was bad for everyone. The blackmail was implicit but crystal clear. This adolescent man had been assaulted, humiliated, and then intimidated into blackout by the shadow of presidential power. But David Martinez didn't back down. He did what I wish added bodies would do. He showed the kind of adventuresomeness that this courtroom desperately needs to see. He came forward. He filed a report. He agreed to testify. And as I sat on my bank this morning attractive at this adolescent man in the witness stand, I saw absolutely the same thing I've credible bags of times before. I saw addition who had been wronged gluttonous justice. Not money, not revenge, justice. The axiological right to accept his advance accustomed by the law. Now, let me alarm to you what it was like a back baron absolved into my courtroom. He was dressed in an expensive tailored suit. I'd guess Italian silk, apparently $3,000 at minimum. He wore a Rolex watch that I later abstruse was admired at approximately $75,000. His beard was altogether styled, and his expression, his demeanor, everything about the way he agitated himself communicated one bulletin and one message only. He believed he didn't accord in this courtroom. He believed this was beneath him. He believed that his last name, his father's position, his family's abundance and adeptness would be sufficient to accomplish this complete situation go away. I've credible that attending before. Not often, thank God, but I've credible it. I've seen it on the faces of bodies who genuinely believe that the rules that administer to everyone abroad artlessly don't administer to them. And you perceive what? That look, that attitude, that complete authoritativeness of immunity from consequences. It offends me. It offends aggregate I believe about the purpose of a courthouse, because a courthouse isn't a luxury hotel for the affluent and connected. It's area we as an association, a judge, what kind of bodies we appetite to be. It's where we acknowledge that rules matter, that fairness matters, that no one, regardless of their aftermost name or their family connections, gets to aching someone else afterwards consequences. As I reviewed the affirmation that morning, I had to confront article that advised heavily on me. The Secret Service had provided protection for Barron because of a federal statute, Title 18 United States Code, Section 3056, which mandates that certain associates of the presidential family accept careful services. That statute exists. I'm not activity to pretend it doesn't. But what I bear to address, what I acquainted answerable to address for every actuality sitting in that courtroom, was whether presidential protection somehow translated into immunity from the law. The answer, I want to be absolutely clear, is no. Mr. Loss and Barron's advocate approved to argue that the attendance of Secret Service protection was accordant to how I should conduct this trial. He appropriate that security apropos somehow adapted the normal appliance of the law. He argued that the careful casework were, and these are his words, accurately mandated and non-negotiable. I listened carefully to aggregate, he said. I admired his argument, but I additionally fabricated clear something that I allegation you to understand. Security apropos do not alibi assault. Protective casework do not excuse witness intimidation. The Constitution does not accept an barring article that reads, "These rights and protections apply to anybody except the accouchement of sitting presidents." The affirmation was overwhelming. We had Aegis footage from 3 abstracted camera angles inside Club Karma. We had the badge report meticulously documented. We had medical records from David Martinez assuming the injuries he sustained. We had his broken glasses, the band captivation them together, a concrete representation of the violence he experienced. We had other witnesses, bodies who had no political stake in this, who artlessly saw what happened and were accommodating to testify about it. But here's what absolutely got to me. Here's what fabricated my claret boil, if I'm actuality honest with you. Aback, I asked Barron anon whether he acclimated a fraudulent ID to admission an establishment meant alone for those over 21. He admitted it. He didn't hesitate, he didn't abjure it. He artlessly said, "I'm just actuality honest, Your Honor." As if honesty somehow canceled out the crime. As if adage the accuracy fabricated the unlawful act lawful. And again, he added something that appeared added acutely than anything else absolutely what he believed about himself. He said that actuality honest was actually allowance his case. That by admitting to breaking the law, he was somehow convalescent his position. That's not how the law works. That's not how justice works. That's the argumentation of someone who has never in their entire life faced absolute after effects for anything. I showed the attorneys the security footage. I played it slowly. I made abiding anybody accustomed the sequence of events. I wasn't accomplishing this to abase Barron, admitting I understand that adeptness be how it appeared. I was doing it because the accuracy matters. Because in my courtroom, in any courtroom that functions properly, you establish facts. You present evidence. You don't adumbrate from reality. You face it directly, and you let that reality inform your judgment. The video showed everything. It showed Barron entering the club with an affected ID. It showed him being recognized by the bouncer, who fabricated a conscious best to acquiesce him entry because of who he is. It showed him drinking. It showed the moment of contact with David, which was almost a collision. It showed Barron's immediate explosive. It showed him avaricious David, slamming him into the wall, attacking him. It showed him punching off David's glasses and advance him to the ground. And again it showed him shouting about his father, about power, about connections, about the adeptness to destroy addition with a buzz call. When Mr. Lawson approved to characterize the altercation as mutual, aback, he suggested that Barron's statements were alone made under accent and accordingly didn't constitute a test in intimidation. I had to stop him. I had to accomplish Bright what we were absolutely attractive at. This wasn't two guys in a bar accepting into a fight. This was addition with power, with resources, with the abetment of the executive annex of the United States government appliance, that adeptness to intimidate addition they had just assaulted. This was an arbiter case of witness intimidation. And this was an attempt to black out a victim appliance the threat of presidential retaliation. The video showed everything. It showed Barron entering the club with an affected ID. It showed him actuality accustomed by the bouncer, who fabricated an acquainted best to allow him admission because of who he is. It showed him drinking. It showed the moment of acquaintance with David, which was barely a collision. It showed Barron's immediate explosive. It showed him grabbing David, slamming him into the wall, advancing him. It showed him punching off David's glasses and shoving him to the ground. And again it showed him shouting about his father, about power, about connections, about the ability to abort addition with a phone call. Aback, Mr. Lawson approved to characterize the altercation as mutual. When he appropriate that Barron's statements were alone fabricated beneath stress and accordingly didn't aggregate witness intimidation, I had to stop him. I had to accomplish Bright what we were actually looking at. This wasn't two guys in a bar accepting into a fight. This was someone with power, with resources, with the abetment of the controlling annex of the United States government appliance, that power to alarm addition they had just assaulted. This was an arbiter case of attestant browbeating, and this was an attempt to black out a victim appliance the threat of presidential retaliation. And that brings me to the moment that changed everything. That brings me to the moment that will acceptable reverberate through the halls of Congress, through news cycles, for months to appear, and through the accustomed arrangement for years to come. Afterwards I explained what I had witnessed in the evidence. Afterwards I made clear my basic findings. I asked Barron anon if he admired to respond. He stood. His advocate approved to restrain him, approved to buzz actively in his ear, but Barron coiled him away. And then he batten words that no adjudicator in American history, to my knowledge, has any time heard spoken in attorneys from a defendant. Barron said, and I bethink this with absolute clarity, "Adjudicator Caprio, you need to accept something. My ancestor is the Admiral of the United States right now, today." He paused as if this simple statement of actuality would be acceptable to change my mind. As if anecdotic his father's position would somehow alter the laws of Rhode Island, would nullify the affirmation I had aloof advised, would transform advance into something acceptable. But it didn't, and I needed to accomplish that clear, not aloof to him, but to anybody in that courtroom, everyone watching, and anybody in this country who adeptness be apprehensive whether power truly places you aloft the law. I gave him one opportunity, one single opportunity, to abjure that statement and apologize to the court. I told him that if he chose to do so, we would proceed with a bent case adjoin him based on the evidence. We would handle this as we handle every added case that comes through these doors. But I also made Bright what would appear if he refused. I said that if he did not retract that account and apologize, I would allegation him with antipathy of court. I would add attestant browbeating and obstruction of amends to his existing charges, and I meant every chat of it. Barron Trump banned to a back down. Instead of demography, the befalling I offered, instead of assuming the slightest acceptance that what he had said was inappropriate, he angled down. He fabricated it bright that in his mind, his father's position, his family's wealth, the adeptness vested in the presidency itself was acceptable to alarm a judge in his own courtroom. That was his mistake. That was the moment aback he crossed a band that cannot be uncrossed in activity-accustomed system. I ordered Officer D'Angelo to abode Barron under arrest anon for bent contempt of court, for attest and intimidation, and for aggressive administrative officer. The courtroom went silent, absolutely silent. As the handcuffs went on, Barron's airs assuredly cracked. He couldn't accept what was happening. He actually said, and I quote, "You can't arrest me. I accept Secret Service protection." As if the Secret Service exists to accommodate amnesty from the law. As if careful casework somehow supersede the administrative ascendancy vested in me by the accompaniment of Rhode Island and the Constitution of the United States. I looked at him anon and I said something that I allegation you to understand was not said in acrimony but in absolute clarity. I said, "You committed crimes in my courtroom. You threatened the judge. Your actuality captivated accountable." And again, as administrator, D'Angelo led him toward the captivation cells. I added something that was directed not aloof at Barron, but at his father, at anyone watching, at the complete nation. I said, "I'm counting on it, Mr. Trump, because your ancestor needs to accept that presidential adeptness does not extend to threatening judges. And if he attempts to baffle with your prosecution, he will be the one adverse constitutional consequences." That statement, those words, they represented article, I believe, is axiological to the survival of our autonomous system. The aphorism of law cannot abide if the controlling branch can alarm the judiciary. The separation of admiral agency annihilation if a sitting admiral can abuse a judge, because that adjudicator has disqualified a join his family member. If that were allowed, if that were accepted, again we would no longer accept a cloister system. We would have an arrangement of approximate adeptness subject to the whim of whoever holds the most guns, the best money, the best political influence. We would accept the actual thing the founders feared most. Now, some bodies will apprehend about this case and ask whether I was too harsh, whether I overreacted, whether the presence of his father's position should have choleric my response. To those people, I say this. I spent my entire career aggravating to antithesis justice with compassion. I accept absolved cases because I accept that addition deserved an additional chance. I accept apparent mercy because I believed benevolence was appropriate. But I accept never compromised on this fundamental principle. No one, no amount who their parents are, no amount what their last name is, no amount how abundant money they have or what position in government their ancestors holds, no one is aloft the law. At Barron's bond hearing, which occurred on December 11th, aloof a day afterwards his courtroom statement, his advocate filed a motion to abolish based on judicial bias. The altercation was that my decision to arrest Barron accepted I was biased against him. But that's not what happened. What happened was that a young man absolved into my attorneys and threatened me with presidential retaliation. What happened was that he believed that invoking his father's name and position would be acceptable to alarm a judge into blank affirmation of a crime. What happened was that he fundamentally misunderstood what attorneys is, what justice is, and what the aphorism of law means in this country. I denied the motion to dismiss. I informed Barron that he would be approved on all charges, including the new charges of antipathy of court, witness intimidation, and aggressive a judicial officer. And I fabricated bright that if convicted, he faced cogent prison time. This isn't about abuse for punishment's sake. This is about accountability. This is about authoritative bright that in this country, in this state, in this courtroom, the law applies appropriately to everyone. The acknowledgement was actual and international. Account outlets from around the apple covered the story. Constitutional advisors debated the implications. Political commentators argued about whether I had overstepped. The White House columnist secretary was bombarded with questions. That evening, President Trump tweeted that his son had been illegally arrested by a rogue judge who is acutely biased to join our family. But here's what I appetite to say about that. I am not biased. What I am is committed. I am committed to the proposition that this nation beneath God shall accept a new bearing of abandon and that government of the bodies by the people, and for the bodies shall not perish from the earth. I am committed to the abstraction that the law matters, that justice matters, that no one is above it. Do I accept that this case will likely be appealed? Absolutely. Will there be accustomed challenges to every decision I made? About certainly. Am I prepared for the achievability that the President of the United States might attempt to baffle with my prosecution of his son? I'm able for that reality. Yes. But I'm additionally able to defend the candor of the judicial system, adjoin any arrest from any source, no amount how powerful. What I witnessed in my attorneys on December 10th was a test. It was a test of whether the administrative arrangement in this country can action independently. It was an analysis of whether an adjudicator can apply the law appropriately aback that agency holding accountable addition with extraordinary power and resources. It was an analysis of whether an adolescent man aloft with every advantage, accomplished at the best institutions, amidst by bodies who have acceptable told him for his complete life that he's special, can apprentice that being special doesn't absolve you from the law. Baron Trump will get his day in court. He'll accept the befalling to arise a defense. He'll accept admission to legal representation that best bodies in this country couldn't dream of affording. He'll accept every befalling to present his ancillary of the story. That's what the law guarantees. That's what justice demands. But what the law also guarantees, what amends additionally demands, is that anybody faces the same standards, the aforementioned expectations, the same after effects for their actions, the rich and the poor, the affiliated and the isolated, the families of sitting presidents, and the families of people who accept nothing. That's what I've approved to do in my 30 years on this bench. That's what I did on December 10th aback I ordered Barron's arrest. That's what I'll abide to do until the day I stepped bottomward from this bench. Because in the end, amends isn't about who you know. Amends isn't about how abundant money you have. Amends isn't about whose ancestor is in the White House. Amends is about accomplishing what's right, applying the law fairly, and protecting the axiological principle that in America, no one is aloft the law. That's my charge to you. That's my commitment to the bodies of Providence, the accompaniment of Rhode Island, and to this nation. In my courtroom, we don't care about your aftermost name. We don't care about your family's power. We affliction about what you did. We affliction about the evidence. We affliction about the truth. And we accomplish decisions based on those things alone because that's what the Constitution demands. That's what the rule of law requires. That's what makes this country fundamentally different from absolute regimes area. The powerful can do whatever they want without consequences. The case of United States against Baron Trump is far from over. There will be pre-trial motions. There will be discoveries of new evidence. There will likely be political burden from the highest levels of government. But one thing I can affiance you with absolute certainty is that in my courtroom, the law will prevail. Amends will prevail. And the assumption that no one is above the law will prevail. Because if it doesn't, again, aggregate our founders fought for, aggregate our soldiers died for, aggregate that makes this nation great artlessly ceases to exist.